Is the Marilyn Manson lawsuit a hetoo Part 2 sequel to the Depp versus Heard suit? The answer is no. In this video, we'll take a look at the actual lawsuit filed by Manson's attorneys and how it compares to the Depp lawsuit, and more importantly, how it's different because they have little in common. The Manson litigation is in the early stages, and at this point, the document that I'm reviewing is called a complaint, which initiates the lawsuit on behalf of Manson. So why don't we first talk about what that is and what it has to have in it. A complaint is a document that the plaintiff files, which involves certain allegations and statements and things like that that are made in the complaint that are sufficient to allow the court to obtain jurisdiction over the parties, the subject matter, and it must state a claim in it, at least one, it can have more, that the court can provide relief for. In other words, a legally recognized claim. In the Depp lawsuit, that was 3 claims of defamation. Johnny Depp said that Amber Heard had lied about him, made false statements that had injured him and cost him money, and defamation. 3 counts of that. So taking a look at the Depp complaint, you see a single defendant, Amber Heard, and you see a single type of cause of action or type of allegation that you can get relief for. Defamation in this case, alleged in 3 different ways. And that was the extent of Depp's claims against her. You said this about me. That was false. I didn't do these things to you. And that initiated the lawsuit. The Manson case is entirely different. In reviewing the Manson complaint, what was surprising was what it did not do. And what it did not do was sue Evan Rachel Wood for defamation. So right off the bat, that is a significant difference from the Depp lawsuit. From the initiation of the lawsuit, these lawsuits obviously have different objectives. They're going to involve different evidence and different claims. So let's look at the Manson lawsuit and see what does it do. So let's look at the first page of the lawsuit. There's Brian Warner, who's the plaintiff, stage name or public name Marilyn Manson, and he's suing Evan Rachel Wood, who is the woman who accused him of abuse, and Ashley Gore, aka Ilma Gore. So right off the bat, this is different than the Depp lawsuit in that there are 2 defendants. And as you move through the lawsuit, you find out that really the prime actor in this situation that Manson has an issue with is Gore and the activities that she conducted allegedly in concert with Wood. There are 4 causes of action listed on the front of the complaint. The first one is intentional infliction of emotional distress. Then there's defamation per se. And then there's violation of the Comprehensive Computer Data and Access Fraud Act, which involves some interesting allegations, and impersonation over the internet, which also involves some interesting allegations. These are the 4 things that they're suing for relief. Let's look at the second one first because that's the one that was at stake in the Depp trial, the defamation claim. This is defamation per se, which basically means it's a type of defamation that is so nasty, allegedly, that you don't have to prove damages to proceed with the lawsuit. Damages are assumed in the lawsuit. However, of course, you do want to prove damages. You want to prove an amount of damages, etc. But it lets the claim move forward even without that because the type of statements made are deemed so reprehensible that the court assumes that you've been harmed if these things were said about you and they weren't true, assuming the other elements of the claim are met. So the defamation claim in this case, which is the second claim that's made out, is not from any statements made by Evan Rachel Wood. Instead, this claim involves statements allegedly made by Gore, who apparently was friend, perhaps lover of Evan Rachel Wood, came into the picture later and has been involved with Wood in various activities related to the alleged abuse and changing statutes and public relations things and things like that. So in this case, Gore allegedly stated to other people that during a short film called Groupie that Manson made, that the actress in the video was a minor and that she was quote-unquote dead. Gore understood the statements to refer to Manson and specifically to mean that his role in the making of Groupie was child pornography, criminal. Indeed, she stated that Groupie was evidence of a felony and that Warner would be indicted as a result. Of course, we don't know yet what Gore's response will be to these allegations of what she said, but it is interesting to me what Manson himself said about the making of this movie before there was a lawsuit at issue. Let's take a look at that, because it's certainly going to be evidence if this case proceeds to trial.
A party at my house.
It was a real party, and we're taping with a real camera.
I said a girl's going to show up, and then something's probably going to go wrong, and you guys just roll with it.
And she comes over, I just know that you live here, and I made this piece of art for you. Will you take it? And you're like, sure, why don't you come in? And he pulls this, like, she must have been 18, literally.
Less, more, I don't know. Whatever, for the purpose
better not be less.
No. She was portraying a youngster.
And then, slowly but surely, and very subtly, he starts to get her to do certain things.
No, but it gets really scary.
That girl is tied up at the end and crying.
Did you get it distributed?
No, because when I showed it to my manager, he said, please hide the masters. If anyone sees it, she'll go to jail and your career will be over.
What's it called?
It was called Groupie.
Sit still.
At any rate, that is the single statement made in this lawsuit that is the subject of a defamation claim, a statement by Gore related to the filming of this movie Groupie. There is not a defamation claim in this lawsuit about the abuse allegations by Evan Rachel Wood. So that is a significant, huge difference to the Johnny Depp case. There is no claim in this case for legal relief involving accusing Miss Wood of lying about the abuse allegations that she made. Now, having said that, the lawsuit does contend that those allegations are false, that they are lies, that it was for motive related to Miss Wood's personal gain and to injure Mr. Manson. But those things are not directly related to this defamation claim or a defamation claim in this lawsuit. So let's take a look at the three remaining claims. The first claim alleged in the lawsuit is intentional infliction of emotional distress. The activities that Mr. Manson says the defendants engaged in that caused him this severe emotional distress include these: initiating an illegal and highly dangerous swatting of Manson in February 2021, soliciting, receiving, and using his logins and passwords for his personal and business social media and email accounts, his address, social security number, etc., without his permission, falsifying correspondence from a fictitious federal agent claiming there was concern for the safety of Wood, other alleged victims of Manson and their families, and an ongoing federal criminal investigation targeting Manson. Here's a picture of that letter. Bizarre. And making knowingly false and defamatory statements against Warner, including that the actress in the Groupie video was a minor and that Manson had manufactured child pornography. Recruiting, coordinating, and pressuring multiple women to make false accusations against Manson and be part of the film project that the defendants engaged in with HBO. So let's take a look at the third and fourth causes of action in the lawsuit. These are somewhat subsets of the first cause of action, intentional infliction of emotional distress, in that they involve specific behaviors that were already cited in that cause of action, but that the plaintiff contends make out their own independent causes of action as well. The first is Computer Data and Access Fraud Act violation, allegedly receiving and using logins, passwords for Warner's personal business, social media, and email accounts without his permission. The fourth cause of action is impersonation over the internet. An interesting set of allegations here that Gore, with Wood's express or tacit approval, credibly impersonated Manson through and or on an internet website and by other electronic means to harm, intimidate, threaten, or defraud Manson. There's previous allegations in the lawsuit in the facts section saying that they had set up an email account that Manson had never been associated with and used it to associate that account with various nefarious things, including illicit pornography and other things that you wouldn't want to have associated with your name. So after looking at this, you see the biggest difference between this lawsuit and the Depp lawsuit is that none of the causes of action in this lawsuit are premised on the idea that Miss Wood lied about the allegations of abuse. It does state in the fact pattern that those allegations are false, but none of the causes of action are based on that or require that finding from a jury. So it's a completely different strategy from the Depp lawsuit. Why would this be? Why would Manson have not sued in order to clear his name under a cause of action that has as its essential element that the allegations of abuse by him toward Miss Wood are false? One answer could be, obviously, that the allegations of abuse are really actually true. That's certainly, if you're on Miss Wood's side, the stand you would take. Another reason could be simply that they feel like, although the allegations are not true, the evidence will not be there to really show that, to disprove it. It could become a quagmire, even more than the Depp trial, and that Marilyn Manson is not Johnny Depp. If you know anything about him, his history, his behavior, the ethos, the music, the statements that he's made, the videos that he's made, he's not Johnny Depp. He could easily be made to look a lot worse than Johnny Depp was made to look in his trial. Miss Wood is not misheard. I think she's going to be a lot more sympathetic. So probably, if you're not going to be able to prove that entirely easily as the plaintiff, a smart move by his attorneys to leave that out. Instead, what Manson's attorneys have done is make a single sniper shot count of defamation related to a statement regarding child pornography involving an actress who is known and who I assume they can establish was not underage at the time that the video was made, and make that the only count of defamation at issue in the case. The other causes of action relate to that, but also to the alleged bad behavior of obtaining his social media login personal information wrongfully and impersonating him on the internet. That if they did that, there's laws against that. They'll be able to show that. So those are the kind of sniper shot causes of action that his attorneys have made at issue in this lawsuit. But by drafting the narrative of the lawsuit to say that all the allegations are false, this is part of a campaign against him, what they've done is put this in the press as kind of a sequel to the Depp lawsuit, that, hey, I've been accused of abuse that I didn't do. This has been concocted. This has been orchestrated as a plan to enrich others, to harm me, and it's not right, and I'm going to stand up for myself as well. So if you perceive from the media coverage that this is essentially a duplicate of the Depp lawsuit, except with the parties changed, that what is at issue in this case is, hey, I want to clear my name. I was falsely accused of this abuse, and I'm putting it all on the line on this lawsuit. Recognize that inside the lawsuit itself, the strategy is very different. The attorneys for Manson have moved this in a different direction, even as they've kept the narrative very similar to the Depp narrative. The final difference in these lawsuits is this lawsuit was filed in California, not Virginia. It is subject to the California anti-SLAPP statute, and those motions have been filed by both defendants. So this case is essentially suspended until those motions are heard by the court, which occurs, I believe, at the end of this year, maybe even early next year. So the case is basically on ice until that happens. So concluding, the original question was, are these lawsuits basically the same? Is one a sequel to the other? The answer turned out to be no, they're very different. In my opinion, it's clever by the Manson attorneys, because these causes of action, being narrow in scope and depending on evidence which is somewhat more objective, such as is the actress underage, or was she at the time of the filming of this video, were the logins wrongfully obtained and then used, not whether people believe or don't believe someone started this fight or that fight. It should be a much lower burden, a much easier time for the plaintiff to make the case to win on these causes of action. Whether that results in him clearing his name or not is a different story. That's part of the overall narrative. But in terms of the lawsuit, they have drafted a complaint which puts them on an easier path to victory than what Depp had. So it will be interesting to see what happens with this case once the motions are resolved and it begins to move forward. All right, that's it. Thanks.